Good morning, Your Honors. I'm Alex Kaczynski, and I represent President Donald J. Trump and all the other plaintiffs in this case, other than Dr. Naomi Wolf, who is separately represented by Scott Street. Mr. Street has graciously ceded me all his time, so I'll be speaking entirely. I also want to acknowledge at council table my colleague Marie Fiala, who is really the brain trust of this team, and I would like to introduce her to the court and commend her. So I'd like to spend as little time as possible on what is nominally the threshold question of mootness. We've briefed it. We don't think the Twitter's come anywhere close to showing mootness, but it doesn't matter. We know for a fact that two of our plaintiffs, Mr. Latella and Mr. Barbosa, have never had their accounts suspended.
So it is undisputed that those two plaintiffs are still suspended as we sit here.
That's right, and there's been no suggestion of mootness as to them. So the case will have to reach the merits, and my suggestion would be to do as Missouri versus Biden did, relying on Rumsfeld versus Fair, says in the First Amendment case, you only need one plaintiff standing. In this case, you only need one plaintiff as to whom it's not moot. Mootness is in any case a fact-intensive inquiry. They claim they've had a change of policy. They claim that this was a business decision. We don't have any discovery. We don't have any way of questioning that. The prudent thing to do here is to find the case is not moot as to two of the parties, and then, of course, I think you should remand, reverse and remand, and then let the matter of mootness be sorted out by the district court.
Since we're talking about the prudent thing to do, you're still advancing the SSMCA claim? The Florida social media statute claim?
I believe so, yes.
So given the Supreme Court's cert grant last Friday in the net choice cases, is there any reason why we shouldn't wait to decide this case until we see what the Supreme Court does?
Oh, there's no reason for you to rule on those at all. The cases were not dismissed on the merits of the two statutes. One was based on an interpretation of the statute or the constitutionality of the statute, and one was based on choice of law questions.
But isn't one of the relevant questions here whether that statute is constitutional or not, and isn't that something the Supreme Court will be deciding in the next 7 or 8 months?
True enough. And if the case is back in district court and the Supreme Court says the statute is unconstitutional, it can be dismissed then. But there's certainly no reason to hold up the rest of the case to wait for a decision that's going to make no difference at this point at all.
Yeah, Counsel, as long as we're on talking about the SSMCA question, I do have a question, and I certainly will be asking Mr. Holzblatt the same question. The district court held on choice of law provisions that the abducted provision could not apply in this case because California law applied. District court noted that the SSMCA that Twitter had not raised the choice of law provision, the forum selection choice of law provision. Do your opponents get to pick and choose which provisions California law applies to and waive as to others?
I'm sorry, you're asking me?
I'm asking you because I'm interested in knowing whether if on a choice of law decision, whether that means that both either do apply or both either do not apply, or whether whether the parties get to pick and choose which provisions of California law they want to apply and which provisions they're willing to waive.
You got me there, Judge Bybee. I had not noticed the question, the issue, and it seems so I'm going to have to talk off the top of my head because you found something I didn't recognize. But yeah, it seems to me that there is there should be consistency, but I'm not prepared to answer the consistency question. Perhaps Mr. Fleischer can. But my view on those statutes is We think that the district court got it wrong on the grounds on which it ruled. If the statute later turns out to be unconstitutional, some hope not be, but it might be, then that can be taken care of at the time the case is back in district court. I can guarantee we will not have a judgment in the district court before the Supreme Court rules. So the constitutionality question really should be of no particular concern.
But if we thought that the district court was correct on its choice of law analysis on the abducted claim, and we thought that there had to be consistency across choice of law, that is, we won't allow parties to sort of pick and choose how choice of law works, that would be an alternative ground for deciding that without reaching the merits on the SSMCA question, wouldn't it?
I think that's right. If I may move on to the merits of the federal claims, we see this as a very simple case. We have made allegations, very broad and yet quite specific allegations, that there was a collaboration, coordination, coercion between the federal government agencies and Twitter. And that as a result of that, our clients' accounts were suspended, and the accounts of those, and this is a class action, of those class members who held similar views. Now, the district court faulted us for not presenting more evidence or was unhappy with the evidence we presented. But on a complaint, the plaintiff does not need to present any evidence. All that we need are plausible allegations.
Well, counsel, on your coercion argument, are you familiar with our relatively recent decision in Kennedy versus Warren? I
know it well.
Okay. So
I must say that I was taken by the concurrence.
Well, the majority wasn't. So in the majority opinion, how does the majority's view in Kennedy v. Warren of coercion, how does that affect your arguments here as to coercion?
Well, I don't think those views are inconsistent. For one thing, Kennedy v. Warren was a preliminary injunction case. So the standard there was for the district court to predict the success on the merits, and for this court to differentially determine whether that determination was an abuse of discretion. That's a very different standard than we have here.
Well, although the majority in the case basically said, with regard to all of the allegations of coercion that were made there, that the reason the district court got it right is essentially because, as a matter of law, there's no there there. And
that was their view. That was not their holding. The ruling is no abuse of discretion. Florid language in opinions are not holdings. If I may say, I thought the concurrence had it right, that in fact, even on those facts, one could, given the benefit of the doubt, infer coercion. But that is not our standard here. The standard here is, have we made a plausible case? Have we made a plausible case? And of course, we have presented considerably more than was the case in Warren. In Warren, the Senator Warren sent a letter. It had no threats. It had no express promises of retaliation. It was a single senator and was not part of a committee hearing or anything of that sort. Here, we have overt threats. We have public threats. We have the executives of Twitter and other social media companies being called in and being forced to say, promise me you're going to censor. Do you promise you're going to censor? And they had to say meekly yes, because, we've all been in those chairs and those hearings, and they're intimidating. And again and again and again. So we have a much broader set of facts. But once again,
Counsel,
Judge Bennett,
in paragraph 55, you have
Of the complaint?
of the First Amendment complaint.
Yes.
The paragraph 55 is all your bullets listing all of the parties who issued threats against you. By my count, you have 2 members of the House of Representatives, 4 senators, statements from Vice President Harris, President Biden, and from the President's tech advisor, Bruce Reed, and then one from former First Lady Michelle Obama. That's a very, very small group of Congress. Why do statements from, let's say, 4 senators at a committee hearing all of a sudden commit all of the power of the federal government to create state action here?
Well, as we have learned recently, a single congressman can dethrone the Speaker of the House.
Right,
So
but that's an internal matter to
not
the House of Representatives. That's their rules, and that's not something we're going to get in the middle of. But this is a question as to whether or not the First Amendment, the Equal Protection Clause, are self-executing provisions can be enforced by the judiciary, because a couple of members of Congress have made some strong statements. I don't know of any case that stands for that proposition. Certainly not the coercion cases. What's your best coercion case?
Encouragement, we've got Missouri versus Biden.
Yeah, and what if I don't accept it? What if I don't accept the Fifth Circuit's reading?
Well, I understand that. If you don't accept the Fifth Circuit's reading, then this should be the first case to do it. We have not had cases involving legislators, but legislators are no different from any other government official.
Well, of course they are. That's a different branch of government, Counsel. That's an Article I power, and they can only act in a collegial fashion.
Well, now look at the Second Circuit opinion in O'Quady. There was a city manager. A city manager is both an executive and a quasi-legislative official. And the court, and this was an opinion from the Second Circuit where Justice Sotomayor was on the panel, said, it is true that he does not have direct regulatory authority, but he can certainly make trouble for the plaintiffs. If he's going around doing what he's doing and sending the kind of letter he's sending, the question is not legislative, not executive, not particularly what their titles are. The question is, would somebody be reasonably cowed by these kinds of statements? And when Nancy Pelosi makes speeches saying we ought to shut down Section 230, when they have congressional hearings where the CEOs of these companies are hauled in and told, promise us that you will do more censoring. They don't have to be able to pass legislation. That's not the test, and that was where the district court was mistaken. The threat is what matters. The threat is what matters. The question is, can a single senator...
But it's always been a threat by someone who had authority to follow through on what they said. Well, these senators do not have... They can follow through, but they've got to persuade a majority of the Senate, and then you have to get a majority of the House to agree, and then signature by the president.
I'm sorry, but that does not... first of all, it doesn't comport with O'Quady. I mean, then you'd be creating a conflict with the Second Circuit. But...
Wait, based on the city manager?
Yeah, the city manager.
Have you got any other case in which legislators made threats that the court found coercion? Other than Missouri versus Biden.
What the court said is, it is true that he had no direct authority. It is true that he had no direct authority, but Molinari had no direct authority, but O'Quady could reasonably believe that those, what he said he would make, actually not O'Quady, the billboard companies could reasonably believe that he could make trouble for them.
Is this the Staten Island case? Is this the Staten Island Borough, the Staten Island Borough President case?
Exactly, Molinari. Staten Island Borough, there were billboards, and Molinari sent letters, and immediately the billboards were taken down, sent letters to the billboard companies. And the question presented...
I would just say that borough presidents have a lot of power.
Well,
a lot of individual power, a lot more than a city manager.
Borough, I may have gotten my term wrong. Borough, yes. But what the opinion said was he did not have direct authority over the billboards. But it then said, yes, but he can make difficulty, and they could reasonably believe that it make difficulty. In this case, when you have powerful senators, particularly when they're on committees, particularly when they call hearings, and they extract promises, and they make statements about how there has to be more censorship. This is America.
You have a final point, Counsel. You're out of time. Do you have a final point?
I wanted to say a word or two about the motion for judicial notice. In our view, we're not trying to get any of that stuff in for the truth or anything else, but remember that the district court standard, the standard applicable is under Townley. Did we make a plausible case? And plausibility is a question of whether the facts alleged in the complaint, in light of the whole world, in light of the real world, are in fact plausible. Make a case that if you're going to go out and get discovery, you're likely to find something.
All right, thank you, Counsel.
We now know what we would have found. We now know what we would have found, and the court should consider that. Thank you. Do I have any time for rebuttal?
No. We'll give you a couple of minutes. We took a lot of your time with questions.
2 minutes is, thank you for the grace.
May it please the court, Ari Holtzblatt for appellees. I would like to address the mootness issue, but first I want to make an important point that I'm afraid might get lost if I don't make it at the outset, which has to do with the timing of the relevant course of conduct here. Mr. Trump and all but two of the other plaintiffs only allege actions during the Trump administration. That makes this case actually very different than the Missouri v. Biden case, the Fifth Circuit case, and I think presents the opportunity to actually not have to clash with the questions that were presented in that case, because that case really was about executive action during the Biden administration. This case, and the questions and the discussion that the court just had, I think makes this clear, is really about communications by legislators to the companies and whether those legislative statements are sufficient to establish state action when the companies act consistent with those actions. And Judge Bybee, I think your question is exactly on. I know of no case that has ever found state action and allowed a claim against a private company. Even the Warren case was a claim against the government official. But I know of no case finding state action and no case allowing a claim against a company based on statements of individual legislatures, certainly not ones like here where there's, when you look closely at the statements, there are questions but no sanctions that are threatened, and the legislators had no power to unilaterally impose sanctions.
Would your argument be the same if, let's say, there were a joint letter from the four leaders of both houses of Congress?
That would be a different case, as I'm sure Your Honor recognizes, and I think it would depend on the nature of the content of the letter and the nature of the conduct that it was demanding. I think actually the Warren case identifies a number of different factors, and I don't think it makes the inability to impose sanctions unilaterally alone dispositive, but it makes that very significant. It also asks what is being asked, what's the tone of the letter, what's the context of the request. And so I could imagine
So you're willing to concede that there might be coercive action if you had a letter from the four leaders of the House and the Senate?
I'm willing to concede that that is far afield from what is presented here and would present a very different case.
I mean, Counsel, this seems to me to be a really dramatic extension of the state action doctrine if we would allow Congress to create legal obligations without acting as Congress. These are letters from four people. They may or may not represent their caucuses. They may or may not have the votes to pass it. They may or may not have the ability to have the president sign it. But all of a sudden, that's going to become state action, and now the Constitution is judicially enforceable? That looks like a huge land grab by us.
I agree, Your Honor. And I think the court does not need to reach that question. All I'm saying is that I don't want to imagine every conceivable hypothetical under the sun where it may be possible that legislators are referring to something that they do have more power over. But I do think that in the ordinary course, and certainly in the ordinary context as presented here, that would be, to use Your Honor's word, a land grab. And I think there's an important piece of context which matters a great deal here, which is that and the full transcripts from these hearings are in the record, and I think it's significant that the companies were hearing it from both sides. Some were arguing that more content should be left up. Others were arguing that more content should be taken down. Section 230 was being discussed by, and continues to be discussed to this day, by members of both parties, and there's a whole host of different positions that people have taken. And I think it's especially dangerous in that context where really almost anything a private actor might do could conceivably be consistent with something that's being demanded.
Counsel, before... No, please.
Can you address Judge Bybee's question to your opposing counsel on the choice of law issue? Twitter did not raise the choice of law provision in the terms of service to bar the claims for the SSMCA like it did for the other statute. Why is that, and shouldn't we be able to consider that regardless of whether or not you raise those issues?
Thank you, Your Honor, and I do want to address that question. I mean, as a preliminary matter, I think that would be a waived argument since it was only brought up at argument. But even setting that aside,
you're arguing that it's waiver of the waiver. That is because the other side didn't raise it. We can't ask you this problem.
You can Your Honor, I think you can certainly ask me this problem, and obviously waiver is waivable by the court, but I think it would be imprudent to waive it here. And but I want to be candid about I want to answer the question.
Yeah, please answer the question.
And I think actually the choice of law question under the two statutes is quite different. And to be candid with the court, the kind of the Unfair Business Practices Act for which Twitter raised a choice of law question, that's a kind of statute that is common in virtually all states. It's certainly common in California. There's a UCL that is essentially equivalent to the Unfair Business Practices Act statute under which the claim is brought in Florida. The Stop Social Media Censorship Act is a very unique statute, and it's one that there is no obvious equivalent within California. And so I think the choice of law question, when you have to analyze it for a court, always is a claim by claim question if it is raised, and I think it would have presented a very different legal question between the two, and so it made sense to us to raise it only for the claim that where there's an equivalent kind of statute in both.
But you invited the district court to find that it was unconstitutional. District court decided on slightly different grounds. But if the district court had held it unconstitutional, or if the district court had found it constitutional, do you then get to raise your choice of law analysis, or have you now waived it? I think probably as a practical matter, I haven't thought about the question. So if possible, I'd like to reserve a little wiggle room, but I think it would probably be waived because we hadn't raised it at the time we had raised our choice of law.
So then let me ask you the same question I asked your friend. Is there a reason, in your view, that we should hold this case until the Supreme Court decides the net choice cases?
Well, I don't think there's any reason to hold the whole case. I think it would be relevant at most to the SSMCA claim, and the application of that statute that the plaintiffs are seeking in this case is retroactive application. That was our principal, or our lead argument below, and the ground on which the district court decided that question. So I think it is a statute that doesn't even apply to the conduct that's at issue here, and I think the district court and this court can reach that question without having to wait on the Supreme.
I'll tell you why this bothers me, counsel. So it bothers me for this reason. District Court said, on the Unfair Practices Act, this is a choice of law analysis, and that doesn't apply. And then he says, don't know why, but we haven't raised the choice of law with respect to the SSMCA. Given that there was an 11th Circuit opinion in place, it feels very manipulative. It feels like you're willing to go forward here because you think you're going to win, given the 11th Circuit's analysis. But it feels very manipulative in this way that parties generally don't get to pick and choose which provisions of a foreign state's law apply if there's a choice of law provision that they think bars some of those provisions. And that's to prevent you from coming in and saying, well, we want to invoke California law as to the cause of action, but if we were to lose on that, we want the limitation on damages provision from Florida to apply, and we waive any objections to Florida limitation on damages applying. So it feels very, very manipulative of the court to kind of pick and choose your choice of law provisions.
Well, I guess I respectfully disagree, Your Honor, and I think I've tried to explain why, which is the choice of law question and whether or not the choice of law provision is enforceable is evaluated on a claim-by-claim basis. And so we have a duty to make judgments about whether we think that that choice of law analysis is going to come out in a way where the choice of law provision would be enforceable, and we think it was correctly enforceable as to the...
Your view is that everybody has some version of a UDAP statute, and since everybody has one, the California interest vis-a-vis its own UDAP equivalent statute is different than a circumstance where California has nothing like the SSMCA, if I have the acronym right, and so its interests in having that in play or not in play are way different than where it has its own UDAP statute.
That's exactly right, Your Honor, and I don't think we should be forced to waive our ability to assert the choice of law as to the one where there's an equivalent statute simply because we've made a judgment that there's a different legal question as to the other type of claim.
So you have or haven't waived the choice of law argument with respect to the SSMCA?
I think I actually am fine waiving the choice of law as to the SSMCA. I think it is a genuinely different legal question, and it's not one that we asserted at the district court. I think what's important is that there's a clear application of standard choice of law principles as to the Unfair Business Practices Act, and the district court was correct in deciding that question. Your Honors, I want to address, if I can, two other issues that came up during the prior argument. One, why does it matter? Why does the mootness issue matter? And I think it matters because, as this court's O'Hanley decision, as the Warren decision, as really all the state action decisions make clear, this is really the relevant question is whether the specific conduct that is at issue can be deemed state action. And so we have to look at the nature of the statements and the timing of the conduct that's being challenged. The question of whether or not Mr. Trump's account was suspended as a result of state action, I think, is potentially a different question, or at least draws in different questions than any other individual. There was a certain context around that, and so I think there is a claim-by-claim analysis. And so, yes, I think it matters that there is mootness as to certain of the plaintiffs, and we're not asserting mootness as to the others. I also think the pleadings question is one that is really resolved by the court's O'Hanley decision. The O'Hanley was decided on a motion to dismiss. The relevant statements that were claimed to be coercive or entwined were before the court, and the court was able to analyze whether or not those statements, that conduct of the government, could give rise to the necessary standard to establish state action under this court's doctrine. I think that we can do the same here. The plaintiffs have put forward the particular statements that they are concerned about, and they're not sufficient. And with respect to mootness, the plaintiffs have received what we think was the core remedy they sought. They've been reinstated. There have been. You
agree that two of the plaintiffs' accounts have not been reinstated, correct?
We're not arguing that those two plaintiffs' claims are moot.
And those two plaintiffs are seeking injunctive relief.
They are seeking. That is correct, Your Honor. But we've filed a motion to dismiss, and we can move to dismiss against individual plaintiffs and their individual claims. And so we do think the First Amendment claims of the remaining plaintiffs are moot and can be disposed of at this stage, or if we went back to the district court, should properly be disposed of there. They've been reinstated.
What do we do with the CEO's statement?
Which one, Your Honor?
The recent statement. So the accounts have been restored, but Twitter has announced that it will reserve the right to suspend accounts going forward. And it was posted on Twitter's website, and it was a statement issued by.
Yes, Your Honor. Thank you. And we're not arguing that there have been. And in fact, to update the court, I know that the particular policies that triggered the suspensions here have not been applied against these plaintiffs, but there have been standard, ordinary content moderation actions taken. And our argument about mootness is not that there's never going to be any content moderation against the particular plaintiffs. This is a state action claim. And so the question is whether or not there is state action that would lead to the suspension of these individual plaintiffs. And if there isn't a suspension in the future, then that would be a new claim, and the plaintiffs would be free to bring it, saying we've now identified what we think is state action causing this new suspension, but we don't think the fact that there's ongoing content moderation Twitter. I'm referring to Twitter for convenience, but obviously X has its own rules and continues to enforce them as all platforms do. But there's obviously a new direction at the company, and these individuals have been reinstated, and we think that gives the plaintiffs the primary relief they've been seeking. With my last 5 seconds, I'll just say this is, I think, an extraordinary circumstance where the Supreme Court has made clear there needs to be a zone of private liberty that is not intruded on by the state action doctrine, and that's why the court has always emphasized it's an incredibly high bar to establish state action. If the court has no further questions, I will sit down.
Thank you, counsel.
Thank you, Your Honors.
All right, counsel, you have 2 minutes.
Judge Bivey, the complaint is not limited to legislators. Look at paragraph 10 of the complaint, ER 327. Defendants, deplatformed plaintiff, and the putative class members at the behest or in cooperation with the approval of Congress and the executive branch.
Yeah, and I mentioned up front that there was statements by the president, the vice president, and by Bruce Reed, the technical advisor.
That is evidence, and we're not required to present any evidence. That's an allegation, and all we have to do is show that this is a plausible allegation. Now, if you go into the 90s, like paragraph 96 of the complaint, we also complain about actions by the executive branch. But we don't have to prove our case before discovery, before we've engaged issues. What we have to do is state a viable claim. And this court has said again and again and again, and the Supreme Court has said, if there is entwinement, if there's sufficient entwinement between the government and a private party, be it coercion or entanglement or whatever, in that case, there can be state action, and the private party can be held responsible. We do not have to present evidence before the complaint. That's not how it works. The way it works is they answer, they have to deny things, which they haven't yet denied, except deniers have made that, we don't engage in any collaboration with anybody. But we know that's false. We know that's false. It's all come out since then. The Twitter files, the Missouri versus Biden are facts. So engaging the plausibility at paragraph 10, and this is what the court has to look at. And there is more, but I'm just pointing to paragraph 10 because it does point to both Congress and executive branch. We have to have made a case that's plausible. It's not crazy. We're not saying the moon is made out of cheese. We're not saying gravity doesn't exist or the earth is flat. We're making a claim that what happened here, what we claimed happened here, and what we could prove if we got discovery, is that the government was all over Twitter, all over them. And we now know they had an office they have offices there.
Thank you, counsel. We have your argument.
Security clearances. Thank you.
We thank counsel for their arguments, and the case just argued is submitted.